So I'm going to start with self-representation, which is the more pedestrian, although I think interesting, aspect, starting at the first point of contact. And this idea of self-representation is the moment one gets licensed and starts advertising or gets a job in a clinic or becomes a professor or an assistant professor or instructor, and you're saying the magic words. Okay? And the issues from an ethical perspective and a legal one are very much kind of consistent across settings. And they have to do with my grandmother's first rule, which is that you have to be honest. She would be delighted and also rather surprised that the state of California agrees with her, at least with respect to mental health professionals. And her whole belief was that in order to have integrity in the world and also to be able to resolve problems in a real way, one had to be honest. And believe it or not, the law says exactly the same thing about our representations of ourselves as professionals. What it does say, interestingly enough, is that we have to be honest and accurate about our credentials and our training. Notice what's absent there. Okay? They're not asking us to be honest about our own feelings, thoughts, our history, but our credentials and training specifically relevant to our professional license. So, where did you go to school? That's a legitimate question. We're supposed to answer those questions in a direct way. That doesn't mean we can't ask therapeutic questions about what they're asking us, but it does mean we need to be accurate and honest in our representations. I want to, just one pet peeve that I've talked about over the years, but I want to emphasize again today. We are permitted ethically and legally to call ourselves specialists or experts. Okay? So, I have been called an expert on occasion. I actually do not like adopting that particular appellation, particularly in court. Those of you who have been in court, being called an expert is not a nice word. Okay, you're not being called nice things. But on the day-to-day, we can say, you could say, you're an expert in working with a particular population. You're an expert in couples and families, Robert. Okay, so you're close as it's going to get. Right? Problem is that when we call ourselves a specialist or an expert, it is putting our both credentials and our experience in legal boxes or in legal bottles. Lawyers and judges tend to look at things according to what the labels are. And so if I call myself an expert, I will be treated as someone who has to meet the highest standard of care at all times. Same with a specialist. So kind of the medical legal way of looking at things is specialist means you have the ultimate knowledge, or expert means you have the ultimate knowledge in this area. Now, I'm a believer that we should all aspire to that and aspire to that level of functioning, but I caution you to not use the word expert or specialist without really thinking about, do I fit that? Would my colleagues agree that I'm an expert or specialist? And also, do I want to carry the burden of having to be at the highest level of a standard of care all the time? And because none of us are perfect, we're going to make mistakes regularly, and if we're expected to be at the highest standard of care, we're going to do mistakes more often. And so my sense is, call ourselves, a clinician, not a specialist or expert in terms of a recommendation, and strive for expertise. But don't bring along the legal baggage with saying. Now, where this comes into play in cases when you're actually called in to be an expert in a case is that courts call us to be experts for a variety of reasons, and it's for a particular case. It's not about a generic expertise. And it's also a very, at least in some instances, low standard. I don't mean to insult anybody who's been an expert here. I've been an expert. But it's a very low standard. It is about whether we can contribute to the judge and jury's understanding of an issue above and beyond their lay appreciation or understanding. So expert witness, in terms of experience and knowledge outside of the normal layperson's knowledge and experience, is not a very high standard. It can be fairly high if we're presenting as an expert about scientific matters under the Taube, and which is a federal standard. But still, that's a different idea. And even if I am qualified, what's called voir dire, I'm qualified as an expert to go into court and testify about prediction of dangerousness or something of that nature, I'm only an expert for that case in that instance. Otherwise, I'm not an expert. I walk out, I'm just my usual, clinician's clothes. I'm not going to advertise myself as a forensic expert. Whenever somebody advertises themselves as a forensic expert, I cringe, because there's no such thing. That would mean you'd have to know every area of forensic work and be an expert in every area, and there's no way you can do that. If somebody says something about you that's not true in your professional capacity, so they say, oh, Dr. Bloom is a licensed clinician who focuses on X, Y, and Z, and you know that not to be true, the duty ethically is to clarify that's not true. I do not specialize in this, or I do or do not have this particular, meet this particular criteria. But we don't have to go out ferreting that people are misrepresenting us. It only is when it comes to our attention in reasonable course, or it should have come to our attention. So if it's in the magazine that I read regularly that somebody claimed that I've done something that I think is patently false, and I fail to acknowledge and address it, that could be a problem. We don't have to search out when people are misrepresenting us. So let's say we're working in the same agency, you work for me, and I say that you're an expert in 12 different areas, and you've never even studied 9 of them, okay? Well, your duty is to come to me and say, Dan, you got a little carried away here. Could we print an erratum? Could we say this is wrong, get a correction out there? And I, of course, would be completely unreasonable and say, no way. I like what this looks like. Well, you need to put in writing that you tried to correct that with me, even if you can't send it out to 10,000 people. So you want to document that. Where this emerges at times is when non-physicians get assumed to be physicians by clients, and then they tell other people about it. So you're providing services, and somebody says, well, my doctor said. And they say, who's your doctor? And then they give your name, right? If somebody tells you about that, a client, obviously we want to correct the misperception. But unless we know about this, we can't correct their misperception. We have to be accurate in our self-disclosures about our credentials and training to begin with. And if we've got it in some kind of written form, like the materials at Kaiser, for example, that you're a psychologist or an MFT or whatever it might be, terrific, because then there's clearly information out there disputing what the person is saying. It only is when it comes to our attention in reasonable course, or it should have come to our attention. Have the opportunity. I want to mention that when we talk about being honest and accurate in our self-representations at the initiation of services, the flip side of that is that if we misrepresent ourselves, we can get in hot water, ethically, legally, okay, criminally in some circumstances. But that misrepresentation for licensing and malpractice purposes doesn't have anything to do with our intent. Intent is irrelevant when it comes to determining whether I've violated the ethics code or whether I have violated the licensing law, because neither of those make any mention of the intent. It is the act of falling below the standard of care or misrepresenting something in the context of my professional activity that is problematic. It is not whether I intended to do that, okay? And that's a little bit odd. Just like the other aspects of licensing law that I mentioned before, while part of it is an inquisitorial model, this model flies in the face of our usual criminal justice model, which requires a combination of 2 things. If I'm going to be convicted of a crime, much more serious activity than most of our licensing violations, if I'm going to be convicted of the crime of kidnapping, for example, I have to not only have engaged in the act, what's called in the Latin, the actus reus. I have to have done the thing. But I also have to have the mental or the intent to do the act, the mens rea, the mental intent to do that. So it's a combination of intent and act that create a crime. There are crimes that require no intent because the intent is assumed by the law. Possession of a fair amount of cocaine, it's assumed that I knew what I was doing, okay? But for the most part, most laws require intent and act. Licensing law, malpractice law does not require intent. All it requires is the act. As psychologists in particular are battling for prescription privileges in different states. Now psychologists can prescribe in New Mexico and Louisiana. Also, if you're interested in moving to Guam, we can prescribe there as well. And
the battle in California that had subsided for a while has been re-engaged with respect to prescription privileges for psychologists. Psychologists put forward 2 bills during this past session that seem to be likely not to pass, and some have actually died in committee. But it has increased the amount of conflict, of course, among guilds between Organized Medicine, American Psychiatric Association, California Psychiatric Association, and the California Psychological Association.
We are permitted, all of us, non-medical mental health providers, are not only permitted, but we have to be able to talk about medication. We absolutely have to. We are usually the people who end up referring to physicians to get meds. It's not the other way around. You know, so clients come to us, we think you need to go to a physician and get medication for this, and we tell them to go see a psychiatrist, or they may see their family physician for meds. We are also not only permitted but encouraged to talk to physicians about medication. And I would guess that there are a number of people in this room who are probably as knowledgeable, if not more knowledgeable, than many family physicians or internists are about psychotropic medications. You know, it's fine to talk to them about it. The only thing we cannot do is prescribe. Okay? So that means that we can't say you should go on this medication, or you should reduce the amount of medication, or you should go off the medication. What we say is you might want to consider a variety of SSRIs. You should talk to your doctor about what those are and what the pros and cons are. Well, do you know what the pros and cons are? Yeah, people get this kind of effect, that kind of effect. Talk to your doctor about what would be best for you given your overall health picture. Okay? And I mean, I encourage folks to refer to a psychiatrist if at all possible, because now basically what's being taught for psychiatry in residency is biopsychiatry. They're basically not being taught to do therapy anymore. They're being taught how to prescribe. Many of them are really good at it. You know, and as things get more and more complex in terms of medications, it's really tough to rely just on the family doc